Hello and welcome to the Rogers Brief for April 21st, 2023. I'm Adam Rogers. Thank you for watching and thank you for listening. I'm going to be covering some stories this week from the US, some interesting cases out of there with the Alec Baldwin movie set situation resolving in a sense, perhaps. Some stuff out of the Fox News big defamation case as well, and the My Pillow guy, Mike Lindell, actually kind of a related situation to the Fox News one. So I'm going to talk about those a little bit, but there's some cases out of Nova Scotia as well that are quite interesting, I think, this week that I'll be discussing. The William Sandeson case is now over. The court broadcast the parole eligibility section of the sentencing decision just yesterday, and Justice Chipman gave his decision on the parole ineligibility for former almost med student William Sandeson. And there's some other cases too I want to talk about. One is involving a lawyer who was charged with assault, but really the decision, it's an appeal court decision, focuses more on the judge that made the decision and the Crown prosecutor. So I'm going to talk about that in a little bit of inside analysis of how lawyers and judges get along, or sometimes don't, as in this case. Another one, talk about the C.P. Allen 15-year-old there that was charged with attempted murder, and there's been a development there in that case as well, and talk about the potential for automatic pardons. I'm just going to end with some thoughts on that. That's coming into the news as well. So we'll start with the United States and come back, work our way back to Nova Scotia and the sort of second half of the analysis here. So first one though, for baseball fans, we're in the best time of the year, or one of the best times when ball season has started, and there was a decision just this week from Major League Baseball suspended Max Scherzer, the all-star free agent signing, big free agent signing by the New York Mets in the offseason, and he's been given a 10-game suspension. If people are watching the games these days, one thing that's really nice is they have the pitch clock in, so the games go a lot faster, but you might notice after certain innings that when the pitchers come off the mound, the umpire will meet them and they'll examine their hands, they'll examine their glove and under their hat, just to make sure they don't have any illegal substances on there, anything overly sticky that gives the pitcher a better grip on the ball. Well, Max Scherzer was accused, found to be, he was told during this game after one inning to wash his hands, after another inning to change his glove, and it wasn't good enough, and he's been suspended now for 10 games. Bring this up, it's kind of a joke in a sense because it's only baseball, but just to comment on procedural fairness. So in this case, it was the same umpire, this Phil Cousy, who's made the same. There's only been 3 pitchers that have been accused and suspended as a result of this, and Scherzer being the third, and they've all come as a result of inspections by this one umpire, Phil Cousy. So all right, that's a flag there. And then what Scherzer's complaining about is that, all right, you get suspended for 10 games. Or you want to appeal your suspension, you appeal that also internally to Major League Baseball. So not good procedural fairness. Most administrative law situations, you would expect there would be some internal process. You appeal it internally up maybe 1 or 2 levels, but then there's an option at least to go get judicial review of those administrative decisions. Not the case here, so Scherzer's going to miss a couple of starts, and anyway, we'll see. Hopefully that doesn't affect the team unduly as they get down to the end of the season in September, October. If they're a game or two be out of the playoffs or out of a good position, they may look back on this. Anyway, okay. So that's one thing out of the U.S. The second one, though, this Alec Baldwin. Alec Baldwin's the next one I want to talk about. Great actor, celebrity, Alec Baldwin. He's had some troubles with the law, some allegations of violence, but this was from this movie set in New Mexico, and the movie's called Rust. It's back filming now, but in Montana. They've moved the production to Montana, and Baldwin was playing a guy who was supposed to be had a gun in his hand, and in the scene he was going to be shooting. Well, the gun, as it turned out, had a real bullet in it, and somebody was killed, cinematographer. So he was charged. He was charged, and others, the armor, or the person that looks after weapons on set, has also been charged. Well, this week the district attorney announced that the charges against Baldwin are being dropped. Now, I talked about this case, I think, a few months ago, and this district attorney, of course, in the U.S., district attorneys are elected, and so that leads to all kinds of, manipulative kind of behaviors and things that you wouldn't see in a nonpartisan scenario. Well, this district attorney, Mary Carmack Altwies, really came off to me as a self-promoter, somebody who was trying to use Alec Baldwin's celebrity to promote her own career and her own sort of agendas. Well, that got changed. She appointed independent special prosecutors. And what that meant, which she seems not to have realized at first, was that she herself had to then recuse herself from the case, which she did. Well, these new prosecutors looked over the evidence a little differently, and with some help from the defense lawyers, found that the gun had been modified before Baldwin had it, because one of the things that came out was Baldwin kept saying, "Well, I didn't even pull the trigger." And everyone's like, well, you must have at least pulled the trigger. It's one thing to say you didn't think there was a real bullet in there. That seems reasonable enough. But to not even have pulled the trigger, well, it turns out there's evidence now has emerged that the gun had been modified before Baldwin got it. And so, in fact, no pull of the trigger needed to happen in order for the gun to fire. So this is what the new prosecutors are accepting as evidence, and so now they've withdrawn the charges against him. Now, in doing so, they've said that they could, if further investigation reveals, lace charges against Baldwin again. It seems unlikely. I mean, it just seemed these were completely improper. Anyway, it's not the actor's responsibility to make sure that the gun is safe. That's somebody else's job. Actors don't have that expertise. You hire armorers, people with weapons expertise on set, and so that should be where the buck stops, which seems to be what's happening here now, that there's some unbiased prosecutors involved, people not trying to further their own careers. Okay, so that's the Alec Baldwin case. We'll see. Be interested to see this movie when it comes out. I'm sure people will be, it's getting lots of publicity for the wrong reasons, but you never know how that can turn out. All right, next story I want to talk about is Mike Lindell. This is the MyPillow founder. I don't have a pillow from MyPillow, but it's a big brand in the U.S. apparently. Mike Lindell has millions of dollars to blow on conspiracy theories and other appearances and such. So he's a big election denier from 2020, denying the results, alleging all kinds of conspiracy theories. Well, including, he's had conspiracy theories against Dominion voting systems, which is on the other end of the Fox News defamation case, which we'll talk about in a minute. But one of the other things he talks about is how the Chinese government has rigged these election voting machines to switch votes, and so he had this data. And he had held a contest where he was offering $5 million for anybody who could prove Mike wrong. A Prove Mike Wrong contest. And this guy, Robert Zeidman, who is a 63-year-old software forensics expert, went to this conference. You had to get invited or get vetted somewhat, and he had some friends in the Republican Party, some Trump supporter friends, and he got himself invited, and everything was fine. He claims to have voted for Trump himself anyway, but he disproved this, and he wrote this 15-page report, and the contest there was an agreement that in the contest that if somebody disagreed with the judges, they could go to binding arbitration. And so these three arbitrators from the American Arbitration Association felt that Zeidman had proved to their satisfaction that this data that Mike Lindell had been providing to all the participants did show, in fact, or didn't show anything, and so the Chinese interference in the 2020 election was not supported by this data. Okay, so then they say, well, you got to pay him the $5 million. Now Mike Lindell is refusing to do so, and so it'll be interesting to see how this comes along. Now, in this case, I haven't read the agreement itself of the contest rules, but it reminds me of the reason I mean, it's a kind of an interesting situation because Mike Lindell is just such a famous conspiracy guy now. Anybody that's watched late night television, the late night shows will have heard the jokes. But it's also reminded me of one of the first cases you hear in law school is this one that's called Parole versus the Carbolic Smoke Ball Company, 1892 case. And in that case, the Carbolic Smoke Ball Company had put out an ad in the paper to say, if anybody takes this product, consumes this product, and gets the flu afterwards, then we'll pay you £100. Well, Carlo took the product, consumed it, and lo and behold, came down with influenza. So what the court, the House of Lords, decided in England at the time was that this was a legitimate. So Carbolic Smoke Ball Company said, well, that's not a real offer. You can't accept it. No, the court found that this was a unilateral offer to the world at large, liable for anybody to take it up. And so it was a legitimate offer. So bring that back to Mike Lindell to say, all right, prove me wrong. Anybody that can prove me wrong gets $5 million. I think he's going to have to pay this. That goes all the way back to 1892, confirmed by the rules of the contest. But he has bigger problems, I'm sure, because he's under lots of court actions, and he must be running low on funds, or at least unsecured funds at this point. So we'll see. All right, so not unrelated to that is the big story out of the U.S. was the Fox News Dominion voting systems defamation case. And I raised this on its own merits, but also as a comparison to defamation cases in Canada. There was a settlement in this case for $787 million. Now, Dominion Voting Systems had asked for $1.6 billion. Multiple times the current or the trading value of the firm, from what I understand. Now, Fox News, this was coming out in dribs and drabs with the news because, what we've been hearing was, on air, Fox News was sort of echoing or amplifying the messages from, President Trump and others that the Dominion voting machines were faulty, were hackable, were being hacked, were providing false data. All of these things about the 2020 election cost President Trump the election in his view and the view of his supporters. So Fox News was talking about this. Well, what we heard in the background was that many of their hosts and the executives at Fox didn't believe any of that themselves, but they kept talking about it on air. So Dominion Voting Systems considered that to be defamatory to their company, and said so. So they sued Fox News for that. Now, as it was coming down, this was a 6-week trial was scheduled. The media, and it settled after the jury was selected on the first day. The lawyers were all mic'd up. They were ready to make their opening statements, and then the settlement came through and was announced by the judge, and everybody was sent home. A lot of disappointment from, I think, other media outlets who were relishing the opportunity to see Fox News hosts and executives on the stand and trying to defend how could you say this on air when you texted this to your friend or whatever. So they didn't get that spectacle. But it wasn't a slam dunk for Dominion Voting Systems either. I mean, they had to show actual malice, the term is, and so that they either knew something, particular statements were lies, or else they were, speaking out with a reckless disregard for the truth. Well, Fox News obviously thought there was some exposure on that front, or else they wouldn't have settled for the amount they did. But like I say, it was less than half of what they had first demanded. So Fox News is taking that as not a victory of sorts, but at least a mitigated disaster in a sense. Now, compare this to the sort of most famous seminal defamation case in Canada, which is Hill versus the Church of Scientology, Toronto case. Hill was a Crown prosecutor, actually became a judge later, so didn't suffer too much from it in a sense. But the Church of Scientology came out and said some things about Hill that were defamatory, and he said his reputation was affected, and he was awarded $1.6 million, which, any lawyer in Canada that knew about the case was saying, well, that's a huge case, and it's been exceeded, I think, since there was a pilot that was fired and defamed, alleged to have been drunk at a party before flying. Turned out not to be the case, and he got, I think, $3 million. But this one, so anyway, nowhere near the scale of the U.S. situation. Now, of course, anyway, this is going to have hopefully an effect on the 2024 election cycle of more honest reporting in the United States. And so we'll see how that turns out. Okay, moving on from the U.S. Up the coast back to Nova Scotia here. A couple of cases that have some a little bit higher profile, I guess. One is the William Sandeson trial. I've talked about that on the Rogers Brief before, and he was found guilty of murder and sentenced, automatic sentence to life in prison. Well, there's a second part to that, which is when can you apply for parole, which is really essentially determining the length of the sentence. 25 years being the maximum. The Crown in this case had asked for 22 years. The defense suggested 10 to 12. He's already served 7.5 years in custody, so whatever the number is going to subtract 7.5. Justice Chipman came down at 15 years, and in some comments, so 7.5 already gone, so 8 and a bit yet to go. Justice Chipman in his comments, and this was broadcast as well, this hearing, with the victim impact statements given, lawyers' arguments, and Justice Chipman's comments broadcast by the court, which is unusual, but that was done yesterday, and the recording is still up on the Courts of Nova Scotia website. That any longer period of ineligibility would be subject to, Court of Appeal striking it down. So there's no point trying to look like you're denouncing something if it's just going to be overturned at the Court of Appeal. That's not proper a proper use of the justice system in that sense. So word from the defense is that they may yet appeal the 15 years. They were asking for 10 to 12. We'll see. 3 years is a long time. It's a big difference in a sense, even though it may not seem much at the moment. But really, it's the difference between another 8 years in jail, 7.5 versus, 10.5. So that's a big difference. Okay. So that's the William Sandeson trial. A lot of tears shed yesterday from what I could see from the broadcast, and difficult situation over for a lot of people there. But it may yet be appealed. We'll know within 30 days whether his legal team has advised him to do that, and he's decided to do so. All right, next want to talk about is come back to the C.P. Allen case out of the student that is charged with attempted murder. Had a knife, brought a knife to school, put it to himself, and then inflicted wounds on a vice principal and a secretary as well. Went to hospital, were hospitalized, non-life-threatening injuries, but anyway. So the question for the court was whether the student was fit for trial. A little early for this kind of an application, I would have thought. He hasn't even entered a plea yet. So everybody's presumed to be fit for trial unless the judge is satisfied on a balance of probabilities that you're not. And so there's got to be evidence about that. In this case, it looked like there was, he's at Waterville in the youth detention center, so he was sent from there to have an assessment done, came back fairly quickly, and that he is indeed fit for trial. Well, to be unfit for trial To be fit for trial, you have to have three things. One, you have to understand the nature or object of proceedings. Basically, you need to understand that you're in a courtroom. And, you're the accused, you're charged with this offense, this is where you are. Very simple. It's a low bar. Second one is also low. You have to understand the possible consequences. Okay, if you're found guilty of this, you might go to jail, you might get a fine, you might get, there's going to be a sentence if you are found guilty. Third thing is you have to be able to instruct counsel. And so that just means having the capacity to do so. What they say, though, is that you don't have to be capable of making rational decisions necessarily, and nobody's going to assess how rational your decisions are. You just have to be capable, and you don't have to be capable of exercising analytical reasoning. You just have to be able to talk to your lawyer and give instructions, understand where you are, orient yourself to time and place. So I thought it was a little premature, since a decision like that, or an application about not being fit for trial, can be made at any time, but most times it is made at the trial itself, because that's when your mental state sort of crystallizes. You might not be fit for trial today, but you might next week. If people are going through treatment, if they've just been through a trauma, and this young guy certainly was, or appears to have been, then maybe in a few months' time, when you're scheduled for trial, you've gone through some counseling, you've talked to people, you're feeling better, you're in a better place, and you're able to understand the possible consequences and all those things. Well, so this seemed premature. I would actually thought that the more appropriate application would have been under 672.11b, which is seeking to have somebody found not criminally responsible because of a mental disorder. So that means that you are unable to appreciate the nature and quality of the act that you've committed. And so if you're in a crisis, of some sort, a mental crisis, and you've lost all sense of orientation, well then maybe you're not responsible for what for the acts you've committed. That's something that you can, you have to look back on the moment and try to figure out what the person was going through at the moment. A doctor, a psychiatrist would try to make this determination and then provide that information and opinion to the judge, and the judge makes the decision. But, to just check out, see whether he was, fit for trial, I wasn't sure that was a useful use of resources at this point. Okay, so we'll see where that goes. He's going to set for plea, I think, in May, and I'm sure he'll plead. Well, we'll see what happens. We'll report on anything that comes along in that case out of CP Allen. All right, next one is an appeal decision, and this is an appeal decision of Justice Tim Gabriel, and it related to a lawyer who was charged with criminal harassment. His name is Don Fraser. I worked with Don, and I worked with the other lawyer as well, and Mary Jane Saunders. So I'm not going to say much about that, although I was not terribly surprised that Don was found not guilty here. He had a trial in front of Judge Bégin, who's the regular judge in Truro, and the case is not the appeal case. So he was found not guilty at trial by Judge Bégin, but it was appealed, and the Crown appealed this, not particularly because of any of the evidence, but because the Judge Bégin, in the Crown's view, Crown was Darcy McPherson, Crown out of Sydney, brought in for the case because he didn't want anybody local to Pictou or Truro, I guess, or anybody that would have regular contact with the lawyers themselves. So they brought in Darcy McPherson out of Sydney, and he was the Crown on the trial. It was actually also the Crown on appeal. I'll come back to that in a minute. But so I'm going to read a few excerpts from this trial decision, or sorry, the appeal decision, which references the trial transcript. So it was after the first witness, Mary Jane Saunders, had testified, and the court, and this was so the morning passes, first witness is done. I think the trial was scheduled for a day or a day and a half. And there was other witnesses scheduled to come that afternoon. So the judge, just before lunch, goes, all right, wondering what's going to happen in the afternoon. Okay, so he says, the crux of this is her. She's the named individual, and we'll call it victim for the sake of where we are now. Miss Saunders is the victim. And then Mr. McPherson, victim's fine. In the criminal code, it's a defined term that, court, yeah, all right, just Mr. McPherson, includes the term alleged. Court, yeah, so I have no idea where this is going, but it's not going well in terms of conviction. I'll tell you this now. What you have here, I'm going to keep an open mind for the rest of it, but you think this through over lunchtime. You have an aggressive and annoying partner at a law firm who likes his way. He's been there a long time, and you have a very emotionally unfit, unprepared person who's managing partner, one of the 3 managing partners. Seems to me, I'll keep an open mind, I haven't heard the rest of the evidence, but it seems to me that a lot, and perhaps all of what was discussed, was in the realm of her job as one of the managing partners. I think you have a very steep hill to climb. I'm not sure you want to spend the rest of the afternoon climbing that hill. I think the prosecution's got to think through. It's a choice you're going to have to make. I've dealt with you for quite some time now, so I suspect I know where this is going. All right, so then he goes on for a little bit there, and they come back after lunch, and Mr. McPherson, they replay the audio from the discussion, and Mr. McPherson says, including this file, says, the Crown is making a motion, an application that you recuse yourself in that regard, and I have to say it's very rare in my career I've applied for a judge to recuse himself. I can only think of twice in the past. The court, including this file back when, I believe. Mr. McPherson, including this file in another matter, I think last year. They're, so far as I recall, the only times I've ever asked a judge to recuse himself, and I've never, of course, asked for 2 recusals on one file. However, I filed a brief, and he references the tab 4 is a document called Canadian Ethical Principles for Judges, and it's prepared by the Canadian Judicial Council, Judge Bégin, of which I'm on the committee. So that's all right. So that's not looking good in a sense for the Crown. Okay, so it comes back to it. In this regard and context, Your Honour's statement that you will keep an open mind has to be seen in the light of Your Honour's statement that it doesn't look good for conviction, and that the Crown has a steep hill to climb. This suggests that under these circumstances, any reasonable person who, in viewing this matter realistically and practically and has thought the matter through, would perceive either actual bias or perception of bias on the part of the judge who made the comment after hearing only one witness, not hearing the 4 other witnesses who are coming, not hearing any argument, making a decision. Court, I didn't make a decision, so don't say that again. I did not make a decision. The court, I told you my concerns. Don't say I made a decision. I'm not saying you made a decision. You just did. I'm saying you said I made a decision. Don't say that again. I said a person. You said you made a decision. And then they go on there a little bit. And then later on he said, I've said 3 times I keep an open mind. Yes, 3 times. Yes, but it's you don't believe me. No, it's very little comfort to the person who hears that where the decision is headed. Now, Your Honour has committed yourself to a position. I have not. I told you that. I have not made a decision. All right. So, what else do I want to get to? Oh, yes. So the judge, again, Judge Bégin, later on says, I've not made a decision. I thought you'd want to hear my concerns to help you through. If you don't want any help going forward, I'm fine with that, Mr. McPherson. We tend to deal with each other, and then something unintelligible. I will not give you any more feedback ever on your trials, and I'll just zip it, and I will wait till the very end and let them fall where they may. But I have zero partiality in this matter. 0. I was just trying to, as Mr. MacDonald said, just trying to move things along. I have an obligation to make sure that things are dealt with appropriately, and if I have concerns, I should bring them up. All right, so, sorry for reading those excerpts, but it was really interesting. And so Justice Gabriel really came down hard on Judge Bégin for those remarks. He said the trial judge was brusque and outspoken, that the Crown, now he says about the Crown as well, was unusually tenacious and refused to cease some discussions even after the judge was prepared to allow him to ask the question, and that neither had their best day. there was like the victim thing, for example. I mean, you don't want to call somebody a victim as a judge until you've made a decision that the person's guilty. So, he was trying to, in shorthand, to say, all right, this is the alleged victim. And, Mr. McPherson is interrupting the judge to say, well, let me define victim for you. All right, the judge did not need that. So what is bias in this situation? There's actual or apprehended bias. And the apprehended bias, what would an informed person viewing the matter realistically, practically conclude? And there is a strong presumption of impartiality on the part of judges. And so ultimately that's where Justice Gabriel came down in the end. He didn't, he said the court doesn't, or this case doesn't cross the very high bar to show judicial bias. But he really blames Justice Bégin for the back and forth. He said no bias on the part of the judge, but this was what they call obiter dicta, which is you've already made the decision, and I'm just going to continue and say this other stuff, and it's not binding on a future court. It's not really, in a sense, part of the decision. It's just a further opinion on the part of the judge. He said that a reasonable person watching this would nevertheless walk away with their respect for the justice system shaken, that the repetition of what occurred in this proceeding would contribute to the erosion of public confidence in this institution. Now, yeah, he puts more of the blame on Judge Bégin. I disagree. Like I as the lawyer, you have the responsibility to know your judge. And if you're the other lawyer, and this happened to me recently, you're watching the other lawyer, and if they're talking over the judge, they're getting, they're getting a little excited, and they can't just let the judge finish their sentence and then take a breath and then respond. They're trying to talk over and argue, being argumentative. As the other lawyer, you're like, wow, this is going great. You see that and you're like, okay, they've lost their focus. You feel like the other side is not, they're scrambling, they're panicking, if they're into that mode. And that's what I see here. I've dealt with Judge Bégin before. I've been in his courtroom. He's fast. He's not rushing things, but he thinks quickly, he speaks quickly, and you've got to go with that, and there's nothing inappropriate about managing the courtroom. If he sees this case isn't going anywhere, then, instead of wasting a full afternoon or potentially another full day of court time, which could be used for other things, the judge has an obligation, a duty to manage those cases and, use that limited time wisely and productively. So to me, this was a case of a Crown just, not understanding this, yeah, he's trying to help you in a sense. You may not like where it's going because you think you have a strong case, and here's the judge telling you don't. Well, you need to accept that, and you have to know your judge, know a little bit about their personality, and be respectful and, do your job, but do it in a respectful way that doesn't negatively impact your client. Now, the other side of this is on the appeal. Like sometimes often it's good to get a different lawyer for an appeal than it is to keep the same lawyer on, because, if things didn't go the right way in the first instance, then they may be set in a certain mindset, whereas somebody with a fresh perspective, particularly in a case like this, where Darcy McPherson was part of the problem in a sense. I mean, he was involved in that discussion, and, it might have been just as much his fault as the judge's. In my view, it was more his fault. Others may disagree, but it's difficult to dispassionately make that argument before the appeal court if you're the person involved and you're trying to, in a sense, not only see that justice is done, but protect yourself and your, justify your own words and actions as well. So thought the Crown should have assigned somebody else to that appeal if they were going to pursue it at all, which I also think they shouldn't have done. So it was unfortunate for the other lawyers involved. For Don Fraser, who had to hire a lawyer for an appeal that was unnecessary, and the other lawyers to have to relive that situation in a sense just by having this decision out there. So unfortunate, bad call by the Crown in my view. And anyway, we'll see. We'll see. I can't, the other problem is there's no, I mean, that this decision is just going to sit there now because there's no reason for anybody else to appeal it. Judge Bejan may wish to appeal it or have something to say about it, but there's no venue for him to do so other than in future cases. So anyway, we'll see what happens there. All right. Last thing, maybe I'll cover this next week, but in more detail. But there's an article out this week from Dale Smith in the CBA magazine called The National, and it's legislation being introduced by Kim Pate, who's a senator, and it's on pardons. Now, pardons aren't pardons anymore; they're record suspensions. This was brought in by the Harper government. You can't just have a pardon and then your criminal record is wiped. You get a record suspension, which shows that you've gotten a record suspension. Well, we don't know what's behind the veil, what's been suspended, but anybody, an employer seeing that record is going to know, well, they used to have a criminal record. So it's not the same as it once was. And so what the discussion is in this legislation is contemplating is some sort of a automatic pardon after a certain amount of time for certain offenses. And I think this is a good step. It's, there's an argument that you're being punished twice for something because you're punished in the first instance and then you have a hard time getting jobs, you can't volunteer, and so it forces you, in a sense, forces the individual back into, forces them out of legitimate society because they can't get a real job, forces them, in a sense, back into criminality and because of their court record. So anyway, we'll see how that goes. We'll be following this legislation through the federal parliament. Not terribly often the things that start in the Senate, especially something like this that the groundwork hasn't been laid yet, so I don't expect anything dramatic to happen right away, but we'll see. We'll follow this along through the parliament, and if it seems to be gathering some momentum, I'll maybe talk about it further in a future Rogers Brief. So anyway, that's it. That was a longer session today than I usually do, but I wanted to talk about that Fraser case and some of the other stuff out of the U.S. So until next week, I thank everybody for watching, and thank you for listening, and we'll see you next time.